Well, folks, I was anticipating this to be filed tomorrow, but it was filed today. It's a response opposing the petition for review by Josh Call and Lisa E. F. Comfer, Assistant Attorney General and Attorney General of Wisconsin. It's only 12 pages. Introduction. This court should deny... Well, before I start, can y'all hear me? Because I always get complaints about my audio not being up high enough. So I'll wait till I get a response from y'all. Alright. This court should deny Avery's petition for review, as he has done throughout this proceeding. In his petition, Avery has rigorously misrepresented the record. As the Court of Appeals repeatedly noted, the law, the lower courts, opinions, and even his own arguments. The only question... We note that Avery's counsel misrepresented some key facts underlying this claim and motion to the Circuit Court in briefing to this court that Avery's misrepresented the facts and material in stating the Brady ineffectiveness claims. We point them out because of the high-profile nature of this case and the resulting need. Misrepresentations are particularly rigorous to note where Avery's arguments wholly stray from the facts. For example, the state never claimed that the bullet FK or FL was used to shoot Halbach in the head. The state's forensic anthropologist found 2 gunshot holes in Halbach's skull bones. The medical examiner found the same thing and opined the cause of death was 2 gunshot wounds to the head. When asked on cross-examination how could tell either the shot was actually fired while Halbach was still alive, and he responded that he could not definitely make the determination, though he had been told by someone else that Halbach's blood was found on one of the bullet fragments, which could have occurred by passing through the brain. At no point did the state's witness testify that the 2 bullets recovered from Avery's garage were actually the 2 bullets used in fatal shots, as Avery claims. It's Avery, not the Court of Appeals, who grossly misrepresented the state's forensic evidence. Avery has also miscast his claims. The petition changes his arguments, raises new ones he forfeited below. For instance, he now attempts to set up the straw man argument that the Court of Appeals misapplied Strickland v. Washington when evaluating claims he himself presented as newly discovered evidence and not ineffective assistance in the lower courts. The misrepresentations of the sort of Avery's petition regarding both the law and the facts are too numerous to list. Properly raised by the case would be whether the Court of Appeals erred when it found that Avery's motions failed to plead sufficient facts that were actually supported by some evidence to both overcome procedural bar and require evidentiary hearing. Even casual review of the record shows that the Court of Appeals correctly applied the law and appropriately held that the Circuit Court was not required to hold a hearing on any Avery's issues because Avery's motions were all utterly devoid of factual support sufficient to lead the conclusions that Avery claimed. Avery's motions were insufficiently pled, and the Circuit Court strict and deny without evidentiary hearing. So at best, Avery asked the court to engage in error correction of non-existent errors. The court is not an error-correcting court. And there is no compelling legal issue here that meets any of the Circuit Court's criteria for review. There is nothing novel, unsettled, or any need of clarification about what a defendant must plead in his Section 97406 motion to be entitled to hearing or to overcome procedural bar and raising claims that have been raised earlier. Nor can Avery show that the Court of Appeals' rejection of his claims is in tension with any United States Supreme Court or published Wisconsin cases. In short, despite what he appears to believe, the fact that Avery's case was the subject of a television show does not absolve him from following the well-established rules of Wisconsin procedure. It does not entitle him to a hearing on insufficiently pled claims based only on a raw speculation and misrepresentations of the facts, and it does not entitle him to the court review of a perfectly sound decision by the Court of Appeals. The case does not meet any court criteria for review, and there are no compelling reasons for the court to hear it. The court should deny Avery's petition. Argument. This case does not meet any of the court's criteria for review. The court's function is to develop and clarify the law. Accordingly, this court does not grant review unless the case presents an important legal issue on which the lower courts need guidance. This case does not present such an issue. The Section 97406 motion that Avery filed in June of 2017 was his third motion seeking post-conviction relief. He had a direct appeal in 2011, and he filed a previous Section 97406 motion in 2013. The Circuit Court denied Avery's 2017 motion and his many supplements to it without a hearing because he failed to show sufficient reason for claiming previously, and the record conclusively demonstrated that Avery could not show he would be entitled to relief on any of the claims. Avery misrepresented the conclusions his experts reached, and otherwise relied only on wild speculation and conclusory allegations. The Court of Appeals agreed, holding that Avery had not provided sufficient reason why most of his claims could not be raised previously, and for those which he did not provide a sufficient reason. He had not provided sufficient material facts in his motion that were supported by the record that could establish ineffective assistance of counsel, newly discovered evidence, Brady, Maryland violation, or constitutional due process claim. Accordingly, there is no law development to be done here. The court has made it abundantly clear that a defendant must show in the Section 97406 motion to overcome procedurally bar and to entitle a defendant to a hearing. The defendant's motion must provide sufficient material and non-conclusory facts: who, what, where, when, why, and how, that, if true, would entitle him to relief he seeks. The defendant cannot just make broad allegations and hope to flesh them out in an evidentiary hearing, as Avery did here. The motion must provide facts that would demonstrate how the defendant would approve each element of such claims, hearing, or court not required to hold on. The court also held quite clearly that the Circuit Court does not need to hold a briefing for the defendant's motion and make conclusory allegations of his record conclusively demonstrates that the defendant is due to no relief. In other words, contrary to what Avery claims, he is well established that the Circuit Court does not have a grant a hearing on allegations pled in the motion the record demonstrates are not true, and the Court of Appeals properly recognized the claims Avery made in his motions were misleading, contradicted by the record, speculative, and did not contain sufficient material facts that would establish what he claimed. Avery's new efforts all reached conclusions that were consistent with Avery's guilt, and in his motion Avery simply falsely represented what they said, meaning it would be impossible for him to establish a hearing, that a trial or post-conviction counsel were ineffective for failing to conduct these tests, nor could he meet the burden to prevail on a newly discovered evidence claim. Virtually all the contents of the Veely CD were indisputably turned over to the defense along with Agent Fassbender's investigation summary telling Avery what the state found on the Dassey computer. Yeah, but they labeled it as Brendan's computer records, not Bobby's like they were. They misled him 100%. Meaning Avery did not plead sufficient facts showing he could prove a Brady violation even if the hearing took place. And there is no due process right to post-conviction DNA testing, so Avery did not even plead cognizable claim about the bone fragments. But even so, Avery did not provide any facts that, if true, would show that the bones from the Manitowoc gravel pit were human and the victims. He could not be the killer and the person who put them there. He did not plead sufficient facts to explain why the bone fragments could be actually or even potentially exculpatory. Accordingly, he failed to plead facts to show how or why the evidence was all material. The Court of Appeals did not require Avery to prove his claims in his motion. It required him to state facts that would lead to the conclusions he reached in his motion. If he provided those facts at a hearing, that precisely the proper pleading standard Section 97406 motion. It also long been settled that the standard also includes providing material facts to establish a sufficient reason why the claims now raised were not raised in the previous motion in the direct appeal, and murder pro se status, indigeneity, which was the only reason Avery provided not raising his claims in 2013. It's not a sufficient reason. Finally, it is beyond argument that statutory claims such as Avery's argument that the state violated Section 968205, which it did not do in any event, cannot be raised in Section 97406. The Supreme Court has also made it crystal clear that Arizona Youngblood does not apply to destruction of evidence post-conviction, nor recognize a due process right for post-conviction DNA testing, meaning Avery did not raise a cognizable constitutional claim regarding the state's releasing some of the bone fragments to the Falbeck family after Avery's appeal concluded in 2011. In short, Avery's motion did not include sufficient materials, fact that would entitle him to a hearing because he did not provide sufficient facts that would entitle him to the relief he seeks. In other words, his motion was insufficient because he did not allege sufficient facts that were supported by the record to show that he could establish any constitutional violations at a hearing. So the record shows that the Court of Appeals did not hold Avery into a higher pleading standard as he claims. It required him to exact same thing that is required of every criminal defendant who files a Section 97406 motion: sufficient, not conclusory facts, actual facts, not guesswork, speculation, or fiction. To show that a hearing would not be frivolous, Avery simply did not meet pleading burden. Nor did the Court of Appeals improperly fail to consider the cumulative effect Avery's claims. The Court of Appeals found each of these arguments to be without substance. Adding them together added nothing. 0 plus 0 equals 0. The pleading standards and constitutes sufficient material and not conclusory facts entitled defendant to hearing had been fully articulated in decades in the case too numerous to count. There is no need for this court to rehash them. The case does not present any novel, unsettled, or important legal issues, and the Court of Appeals' opinion applying the pleading standard is exactly in line with the decision of the Court and Supreme Court of the United States. Review here would be simply another walk down the extremely well-trodden path of pleading standard for Section 97406. There is no need for further clarification of pleading standard. Courts across the state easily, properly apply it every day. The Court's scarce resources should not be spent reviewing the Court of Appeals' simple and correct application of standard that has already been exhaustively explained in existing case law. Conclusion: this Court should deny Avery's petition for review, dated this date, 8th December 2021, respectively. Josh Call, Lisa Comfort. Yeah. I hereby certify the response confirms the rules contained, blah, 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 yada, yada, yada. Yeah, so I'm not surprised. I'm surprised that it came out a day early because I was expecting this to be tomorrow, but I don't know. It's like a chess match. I don't know. I don't see him getting anywhere with the Court of Appeals or Circuit Court. And who knows what's going to happen when she does take it to Supreme Court. Are they actually going to see his case? I mean, she's basically taking the same steps now that Brendan Dassey took. So, yeah. Well, it's some news. It's not good news, but as soon as I hear something new, I will be back with y'all. Y'all have a great day, and see y'all later.